Today, we are tearing into a terrifying story of tragedy, of misplaced revenge, and a piece of technology so powerful it almost broke the Fourth Amendment.
Hmm.
We're talking about a horrific crime, the arson and murder of an innocent family of 5 in Denver, a case that went completely cold for months until detectives turned to a single, highly controversial tool, a Google search bar.
That's exactly right. And our mission in this deep dive is to really explore that collision point.
Yeah.
Public safety on one side and our foundational constitutional right to privacy in this digital age on the other.
Okay.
We have a whole stack of sources here detailing the tragedy from 2020
Yeah.
and, of course, the high-stakes legal battle that came out of it, Colorado v. Seymour. And this entire case, it really hinges on this novel police technique called a reverse keyword search warrant.
A digital dragnet.
It's a digital dragnet. It's swept up potentially countless innocent users just to catch 3 teenage suspects. And we need to understand how it works and really analyze why so many legal experts, even Supreme Court justices, view this as one of the most dangerous intrusions into our private lives today.
Before we even get into the warrant that cracked the case, we have to start with the human cost, which was just devastating. This all happened in August 2020 in the Green Valley Ranch neighborhood of Denver. And the victims were 5 members of a Senegalese immigrant family. And I think it's so important to stress this. They were completely innocent people just caught in this unimaginable act of violence.
The victims were 29-year-old Jibril Dial and 23-year-old Ajit Dial, along with their little 2-year-old daughter, Khadija.
Oh.
And also killed were 25-year-old Hassan Dial, who was living with them, and her 6-month-old baby, Hawa Bey.
An entire family.
An entire family. The fire that just consumed their house on North Truckee Street was swift, it was brutal, and the senselessness of it all, the fact that it was an act of revenge that targeted the wrong address, it just added this whole other layer of grief and confusion for the community.
It must have been an immediate crisis both locally and, internationally, given their roots. You have an entire family wiped out, and for months, absolutely no suspects, no motive, no evidence leading anywhere.
Nothing.
The sources really emphasized that for investigators, this was a race against time, but they had literally nothing to go on.
Precisely. And the key difference here, between this crime and so many others, is that there was no typical motive. It wasn't domestic, it wasn't financial, it wasn't political. It was just a mistake.
Yeah.
A pure, tragic mistake. And that made tracking down the people responsible through traditional means, well, it was nearly impossible at first.
Okay, let's unpack this, starting with the original event that set this whole tragic chain in motion.
So the root of this whole devastating fire was unbelievably a petty street crime. A 16-year-old named Kevin Bowie was robbed. He lost his cash, his shoes, and his iPhone. And Bowie was just, immediately consumed by this need for revenge.
And this is where we see that pivot, right? From a sort of an analog crime, the actual theft, to a completely digital obsession for revenge. He didn't go looking for clues on the street. He went straight to his tablet.
Exactly. He used the Find My iPhone function on his iPad. Now, look, the Find My app is an incredibly powerful tool. It gives you location data.
Yeah.
But it's not infallible.
Not by a long shot.
And it pinged his stolen phone to a specific residence, 5322 North Truckee Street. So Bowie, operating under this absolute belief that the thief, or at least the phone, was inside that house, he gathered 2 accomplices, Gavin Seymour and another teenager, Dylan Siebert.
And that single faulty digital lead sealed the fate of the Dial and Bay families.
It did. The sources indicate the teens, they only intended to maybe terrorize the people inside or get the phone back.
Yeah.
But it escalated. Baya later confessed they broke into the residence and poured fuel in the living room, setting the fire while the family was likely asleep upstairs. And the tragedy is just so profound. The Dial family had absolutely no connection whatsoever to that initial theft. The location data, the one thing the teens relied on for their revenge, was just slightly off.
And the immediate aftermath was just a complete investigative nightmare.
For months, the case was totally cold. Detectives had security footage, showing 3 masked figures running from the scene, but no identifying features.
Yeah.
Nothing.
Just shadows.
Just shadows. They tried everything in the traditional law enforcement toolkit.
Yeah.
They looked at cell tower data. They even executed geofence warrants, which we can get into those later. But they were already controversial in their own right.
Right.
They're trying to identify any devices that were in the area. They followed up on hundreds of tips from the public. But nothing provided a concrete link to a specific suspect.
And that investigative failure is absolutely crucial to understanding the legal fallout that comes next. The sources, including the court documents from the defense, They all describe the warrant they eventually used as an act of desperation.
Yes.
The police were under intense public pressure. They had exhausted every conventional method for almost half a year, and they had come up with nothing.
And that desperation provides the critical context for the technique they chose. I mean, traditional policing demands that you have a specific individual in mind before you go searching their private property.
Right, you start with a suspect.
You start with a suspect. But when the pool of suspects is potentially everyone, and you have a dead end, law enforcement starts looking for tools that invert that constitutional requirement.
And that inversion led them straight to the digital Dragnet. Okay, here's where it gets really interesting, because the breakthrough came from what is now known as a reverse keyword search warrant.
We really need to spend a serious moment defining this technique, because it flips the whole Fourth Amendment concept of searching for evidence completely on its head.
Okay, break it down.
Imagine the police recover a piece of paper that says 53112 North Truckee Street. A traditional warrant would say, "We have probable cause that John Smith committed this crime, so allow us to search John Smith's papers for this address."
Right. It starts with the suspect, John Smith.
Exactly. A reverse keyword search warrant starts with the evidence, in this case, the address, and it demands a list of everyone in the world who might possess that piece of evidence. It allows law enforcement to submit a specific search term, or in this case, a specific address, and a defined time frame to a data provider like Google.
And then they compel Google to identify the accounts and IP addresses of every single person who searched for that information.
Every single person.
It's not just a fishing expedition. It's asking Google to drain the entire ocean so the police can look at all the fish.
That's a powerful analogy, and it's pretty accurate. In this specific Denver case, law enforcement knew they were looking for someone who had researched the house shortly before the fire. So they requested that Google provide IP addresses and account data for any user who would search variations of 5312 North Truckee Street within a very tight 15-day window leading up to the August 5th fire.
That targeted time frame is so important, isn't it? It suggests pre-planning. It suggests intent.
It absolutely does.
So what was Google's initial reaction to such a broad, unprecedented request like that? Did they just hand over the data?
The sources confirmed they initially resisted. Google often pushes back on what it deems to be overly broad requests. And I mean, think about the scope of this search, asking for data that could potentially involve any of Google's billion global users. It's staggering.
But they eventually complied.
They did. Law enforcement had gone through the proper procedure with the judge. They obtained a warrant. And after some negotiation, Google complied with the warrant and provided that specific requested data set.
And what did that initial compliance yield? What data did they actually give the police?
The result was a spreadsheet. It showed 61 specific searches for the address or variations of it, and those were linked to 8 different Google accounts.
61 searches for one private home address in just 2 weeks.
Exactly. I mean, think about that number. That is highly abnormal traffic for a single home address, and it immediately signaled to the analysts that something intentional, maybe even obsessive, was happening. And crucially, at this stage, the police didn't have names. They just had IP addresses and account identifiers.
So the Dragnet worked. It narrowed the scope from billions of potential users down to just 8 mysterious accounts. How did they make the jump from those 8 accounts to 3 specific teenagers?
So this is where the police used that initial IP data as probable cause for secondary warrant. They quickly winnowed down the list of 8, focusing on 5 accounts that had a definitive nexus to Colorado. And then they went back to the magistrate judge and obtained further, highly specific warrants, not for broad keyword data, but for the cell phone location data, social media profiles, and communication records tied directly to those 5 accounts.
So the investigative process became sequential. The, let's say, legally questionable keyword search laid the foundation for all the subsequent legally sound searches.
That's it, exactly.
Yeah.
And that secondary data trove was damning. The cell phone location data confirmed that 3 of the accounts, Bowie, Seymour, and Siebert, moved in coordination from the Lakewood area to the Truckee Street area precisely during the time frame of the fire.
Wow.
And the search data itself just showed the depth of their pre-planning.
What other details did the suspect's digital footprints reveal?
Well, the teenagers didn't just search the address once. They had collectively searched it dozens of times. And most incriminatingly, they had searched for floor plans of the property on Zillow.
Floor plans. That changes everything.
It does. That detail moved the crime from a potentially spontaneous act of revenge to a calculated, pre-planned execution. And this evidence, which confirmed both their intent and their location, led directly to the arrests of Bowie, Seymour, and Siebert about 5 months after the fire.
So a cold case was solved, a horrific crime avenged, all because of those search queries. But the moment this powerful evidence was introduced into the legal system, everything just exploded. The success of this technique immediately launched a critical legal debate about privacy.
It did. The focus shifted immediately to Gavin Seymour's case, which became Colorado v. Seymour. And everyone involved, from the defense to the prosecution, they all agreed that this single keyword warrant, the digital dragnet, was the linchpin of the entire prosecution.
The linchpin. So if the court ruled that initial warrant was invalid, all the dominoes would fall.
All of them.
So let's get into the constitutional core of this challenge. Seymour's lawyer, Michael Juba, argued for suppressing all of that evidence. What specific legal standards under the Fourth Amendment did he argue the warrant violated?
He argued the warrant violated the protection against unreasonable searches and seizures on two primary fronts, probable cause and particularity. These are, the twin safeguards provided by the Fourth Amendment.
Okay, let's define those clearly because they are absolutely essential here.
So, probable cause requires a police officer, before they get a warrant, to demonstrate facts that would lead a reasonable person to believe that a crime has been committed and that the search will uncover evidence of that crime. The key here is that probable cause traditionally attaches to a specific person or a specific location tied to a crime.
And particularity.
Particularity is the safeguard against general exploratory searches. It's what the founders were so worried about. It demands that the warrant specifically describe the place to be searched and the items to be seized. It prevents the police from just launching a limitless investigation once they step inside your home or access your data.
So how did the defense argue that this reverse keyword warrant failed both of those standards?
It failed, the defense argued, because it was a general warrant. When the police asked Google for the data, they had no probable cause whatsoever that any specific user among the billions who use Google was involved in the crime.
Right.
They were searching the search history of potentially billions of innocent people merely based on the fact that those users performed a query that happened to match an address. And that violates the requirement for individualized probable cause.
And on particularity?
Well, while the warrant was technically particular about the search term, the address, it lacked any particularity about the users whose private data would be seized. It just scooped everyone up.
So if the Colorado Supreme Court agreed with that assessment, they would have been forced to suppress the initial search, right? And under the exclusionary rule, all the evidence that came from it, the phone location data, the Zillow searches, the confessions, all of it would have been inadmissible.
Yes.
That would have effectively collapsed the entire murder prosecution.
That's exactly how high the stakes were. And the court, well, they delivered a remarkably complex and really a partial victory for privacy advocates in its ruling, Colorado v. Seymour.
Okay, so tell us about the privacy win part of it first.
So the court delivered a very strong foundational ruling here. It explicitly ruled that users have a constitutionally protected privacy interest and also a possessory interest in their Google search history.
Wow.
Even if that history is initially only revealed through an IP address. This is a monumental finding. It recognized search history as the modern digital equivalent of highly sensitive private papers and effects that the Fourth Amendment was written to protect.
They are essentially recognizing that your digital life is an extension of your physical self and that it's protected by the Constitution.
Precisely. And the court went even further. It noted that search history implicates fundamental rights like freedom of expression and the freedom to associate or inquire, stating that any intrusion into this sensitive area requires scrupulous exactitude. And following that line of reasoning, the majority concluded that the warrant required individualized probable cause, meaning the police needed a reason to believe each searched user was involved. And since they didn't have that, the court formally declared that the reverse keyword warrant was constitutionally defective.
So the Supreme Court of Colorado said clearly this type of warrant is illegal under the Fourth Amendment because it lacks individualized probable cause. That should have been the end of the evidence.
It should have been. But this is where the complexity and the massive controversy comes into the discussion. The court ultimately affirmed the use of the evidence by applying the good faith exception to the exclusionary rule.
Okay, we need to take a deep breath here and fully explain the good faith exception. We can't just brush it off as the police didn't know better. What's its legal foundation and why did the court use it here?
The exclusionary rule is a harsh penalty, right? Evidence obtained illegally must be excluded from trial. The good faith exception, which was established most famously in the 1984 Supreme Court case United States v. Leon, is a major exception to that rule.
Okay. It states that evidence obtained under a technically defective warrant can still be used if the officers who executed it were acting in objective good faith, relying reasonably on the judge's authorization.
The purpose, as I understand it, is to deter police misconduct. So if the police genuinely believed the warrant was valid because a judge signed off on it, punishing them by excluding the evidence won't actually deter future bad behavior.
That is the rationale. And in the Seymour case, the Colorado court applied it. They reasoned that because reverse keyword searches were a novel and a cutting-edge technique, the law regarding their legality was not well established at the time the police acted. So they found the officers had an objectively reasonable belief that the warrant, signed by a magistrate, was valid. And therefore, suppressing the evidence wouldn't deter future police misconduct because the police thought they were following the rules that existed at the time.
That feels a little bit like the judiciary passing the buck. They admit the search violates the Constitution, but they use this exception to avoid suppressing crucial evidence in a really high-profile murder case. Many critics, especially civil liberties advocates, they see it exactly that way.
Yeah.
They argue that using the good faith exception in cases involving these new, untested surveillance technologies effectively acts as a judicial rubber stamp. It encourages law enforcement to push the boundaries of technology, knowing that the courts might excuse them later if the law is unclear. It provides sort of temporary shield for constitutional breaches.
And this brings us to the powerful dissent Justice Monica Marquez's reaction. What was her primary alarm bell regarding the use of the good faith exception here?
Justice Marquez's dissent was a profound warning against what she saw as the erosion of the Fourth Amendment. She didn't mince words. She argued that searching a database of 1 billion Google users' search histories was exactly the kind of wide-ranging exploratory search that the founders wrote the Fourth Amendment to prohibit.
She connected it directly back to history, didn't she?
Absolutely. She drew a direct parallel to the reviled general warrants of the colonial era, those warrants that gave British officials unlimited authority to search anyone, anywhere, for anything. The Fourth Amendment was specifically designed to outlaw those, and Marquez argued that the majority ruling, by excusing the officers, essentially gives constitutional cover to law enforcement to continue using what she saw as a modern digital general warrant. Her fear was that the ruling, rather than deterring these things, was actually normalizing them.
It seems like the Colorado Supreme Court tried to achieve two contradictory goals at once. Affirm the right to privacy in our search history, but also make sure justice was served in this specific tragic case. And the good faith exception was the bridge they used to avoid suppressing the evidence.
That is the core legal conflict. The majority tried to signal that future reverse keyword warrants might be struck down, saying they would proceed incrementally, but the dissent argued that the damage was already done. Once law enforcement sees a path to a successful prosecution using this method, the incentive to keep using it, or similar reverse techniques, just becomes overwhelming.
So, if the legal system is acknowledging that search history is uniquely protected, the modern equivalent of our private papers and effects, what makes this data so much more sensitive than other digital trails police already collect, like phone records or traffic camera data?
The difference really lies in the intimacy of the information that's revealed. Legal scholars universally view search history as arguably the most sensitive data we produce. When you sit alone with a search bar, you reveal your deepest fears, your vulnerabilities, your darkest curiosities, your secret intentions.
Can you give some examples of the kind of information that's revealed that is considered so legally protected?
Certainly. Think about queries that represent immediate need or vulnerability or uncertainty. Searches for specific diseases, relationship advice, financial distress, highly sensitive medical procedures like abortion clinics near me or is my husband gay? This data is a direct window into a person's political associations, their health status, their sexual identity, their mental state. It goes so far beyond mere location or communication logs. It reflects the unexpressed mental process itself.
The founders were concerned with preventing the arbitrary seizure of pamphlets in private journals. And now, the government can potentially sift through the digital records of every private thought we express through a keyboard.
That's the modern analogy. And if we look at Supreme Court precedent, this issue of digital intimacy has been tackled before. We can draw a direct line to the landmark 2018 ruling, Carpenter v. United States.
Remind us what Carpenter established regarding location data.
In Carpenter, the Supreme Court dealt with the long-term collection of cell site location information, or CSLI. That's the data created when your phone connects to cell towers.
Right.
Law enforcement had argued for years that this was simply business records provided by third parties, and so it wasn't protected by the Fourth Amendment, based on the old third-party doctrine. But the Supreme Court majority explicitly rejected that. They ruled that because CSLI creates an intimate window into a person's life, revealing their movements, their associations, familial, political, religious, sexual, that a warrant based on probable cause is required for access.
So if CSLI, which only shows where you were, requires a warrant, then the legal critique has to be that search history, which reveals why you went there or what you were thinking, requires even stricter protection.
It absolutely does. Search history is exponentially more revealing than mere location data. Location data might show you visited a hospital. Your search history might show you were researching chemotherapy options right before that visit. The composite picture created by search history is often far, far more intrusive than the location data they discussed in Carpenter. And that's why privacy experts view the reverse keyword warrant as circumventing the entire spirit of the Carpenter ruling.
Which leads to the most provocative legal critique of all, that this technique enables a form of thought surveillance.
And it's not hyperbole. Critics argue that by creating a mechanism to identify people who search for potentially sensitive or dangerous terms, whether that's related to a bomb-making manual, a protest location, or even an illegal political party, the government is identifying people based on what they are thinking, not what they have done. And the danger is that police could potentially file charges based on preparation, or even just curiosity, invading a person's private ideas before any criminal act ever takes place.
That violates a really dunkly established common law principle, doesn't it? The idea that we can't be tried for our thoughts alone.
Precisely. Historically, common law recognized that the thought of man shall not be tried, for the devil himself knoweth not the thought of man. And keyword searches risk violating that principle by turning private digital inquiry into potential evidence of intent. You're punishing or scrutinizing thoughts demonstrated purely through a search bar query. When you allow a government to reverse engineer intent from searches, you are fundamentally undermining a core element of personal liberty.
And reverse keyword warrants aren't the only technology drawing these general warrant criticisms, are they? Let's briefly contrast this specific method with the more commonly discussed geofence warrants.
Right. Both fall into the category of reverse or untargeted bulk surveillance, and both are digital dragnets. A geofence warrant, or reverse location search, is based purely on geography. It asks Google or other providers to identify all devices, and by extension all users, who are physically present within a specific, defined geographic area during a defined time frame. It's like drawing a digital circle around a crime scene.
And the keyword search is based purely on a text query.
Correct. The reverse keyword warrant identifies all users who searched a specific term during a defined time frame, regardless of their physical location. Both techniques are highly criticized because they inherently violate particularity and they inevitably sweep up countless innocent people in the process.
We saw that in the Denver case, didn't we? The keyword search captured data from 8 accounts, but only 3 were the actual suspects. What about the other 5 innocent users whose data was seized by the police?
Their private search data was handed over to law enforcement and analyzed, simply because they happened to search the address of an arson victim in the relevant 2-week window. They were completely innocent, but their privacy was violated nonetheless. And this is the central failing of the Dragnet. It treats every user as a potential suspect based on association, not on individualized probable cause.
So, given the massive scale here and the constitutional stakes, how is the industry responding? Is Google fighting these, or are they just routinely complying?
Google's stance is nuanced. They're often compelled to comply by judges who issue the warrants, but the sources confirm that Google has, at times, supported legislation aimed at banning both reverse keyword and geofencing warrants. They recognize the high privacy stakes involved. Legislators in New York, for instance, introduced a bill that would ban both practices, acknowledging the danger of allowing law enforcement to engage in this kind of digital phishing.
And the volume of these requests suggests this is not a rare occurrence.
Far from it. Law enforcement is actively exploring and using these tools. In 2021 alone, Google was reported to have received well over 50,000 requests for user information in just a 6-month window.
Wow.
So when you consider that Google processes billions of searches every day, the concept of a magistrate issuing general warrants for this information and a corporation complying is genuinely horrifying to civil liberties advocates. It makes the prospect of widespread thought surveillance very, very real.
So what does this all mean? The question becomes, At what cost do we pursue justice when the investigation requires an intrusion of this magnitude, sweeping up potentially innocent people's most private digital thoughts?
It forces us to balance the need for justice in a tragic case, where technology achieved an outcome that traditional police work simply couldn't, against the long-term systemic cost of the constitutional rights of potentially billions of users. The short-term benefit of solving one crime has to be weighed against the precedent that gets set for mass surveillance.
We started with a senseless tragedy that shocked a Denver neighborhood, and we've navigated this novel technology used to solve it. Let's bring this case to its final resolution before we look at the ultimate legal cost of that digital search.
The arrests that followed the digital Dragnet eventually brought closure to the Dial and Bay families. The three teenagers involved were prosecuted. Kevin Bowie, who was the primary actor and 16 at the time of the crime, was prosecuted as an adult and pleaded guilty in May of 2024 to the murder and arson charges. This was a critical closure for the community, but it happened only after years of legal maneuvering.
And what was the outcome for the other key player, Gavin Seymour, the one whose case this all hinged on?
Gavin Seymour, whose case provided the legal vehicle for challenging the keyword warrant, was sentenced to 40 years in prison in March 2024. And during his sentencing, he offered a deep apology, acknowledging the gravity of his actions.
What did he say during the sentencing that indicated his remorse?
He was quoted as saying, "If I could go back and prevent all this, I would." And he conveyed that there is not a moment that goes by that I don't feel extreme guilt and remorse for my actions.
Hmm.
The third teen, Dylan Siebert, who was only 15 at the time, was charged as a juvenile. So justice was served for the victims' families. But the mechanism used to achieve that justice, that reverse keyword warrant, has irrevocably complicated the landscape of Fourth Amendment law.
So if we synthesize the major legal takeaway from Colorado v. Seymour, what does this case ultimately represent about the state of digital law today?
This case is the defining moment where a senseless tragedy collided head-on with sophisticated nascent technology and the constitutional requirements of the Fourth Amendment. The Colorado Supreme Court left us with an almost paradoxical outcome. They affirmed the constitutional principle that the search of user search histories was illegal because it lacked individualized probable cause. It was, by their own definition, constitutionally defective. But they used the good faith exception to excuse the police because the technology and the law were so new.
It's essentially a temporary stay of execution for the digital dragnet, justified only by the novelty of the technology itself.
And that's the profound danger. By invoking the good faith exception, the courts are avoiding a substantive ruling that would definitively suppress this practice, which many legal experts see as a clear violation of the prohibition against general warrants. Justice Marquez warned in her dissent that this incrementalism risks allowing a practice that fundamentally invades the privacy of potentially billions of users to become normalized as routine, uncontroversial police work.
Right.
The court acknowledged the search as a problem, but they excused it by claiming the police didn't know better yet. The moment the law becomes clear, that good faith defense just evaporates.
So, since the court explicitly stated the reverse keyword warrant lacked the necessary individualized probable cause, and given that the technology is no longer novel, it's an established tool now, how long will the good faith exception, which judges often use to avoid ruling on these substantive Fourth Amendment questions, continue to protect law enforcement utilizing novel technologies that infringe on the rights of a billion users? It leaves us wondering who is truly protected as technology advances faster than the law, and whether the next digital dragnet will finally force the judiciary to enforce the constitutional standard and suppress this kind of unprecedented bulk surveillance.